Hello, and thank you for joining our December webinar titled Protecting Your Clients from Medical Debt Collections. I'm recording introductions separately since that part of the webinar was cut off. My name is John Blake. I'm the Director of Sales here at Gemini Legal, and I will be co-moderating the webinar today. Helping me moderate is David Camano, who is our Business Development Manager from the Orange County and San Gabriel areas. He was instrumental in helping put this together, so a special thank you to him. We have two attorney panelists joining us today. The first is Joseph Richards. Mr. Richards is a certified legal specialist in workers' compensation law by the State Bar of California, California Board of Legal Specialization. As an applicant's attorney and later a defense attorney, Mr. Richards has appeared before just about every workers' compensation appeal board of Southern California on matters such as liens, AOE, COE, priority conferences, threshold issues, expedited trials on issues of medical treatment and temporary disability, mandatory settlement conferences, and trials of cases in chief. In May 2014, Mr. Richards entered solo practice in Santa Ana, again exclusively representing applicants in workers' compensation claims from the filing of the applications for adjudication to resolution. Mr. Richards now spends approximately 90% of his practice time as an applicant's attorney in the California workers' compensation system with regular frequency. The other 10% is split between labor and employment law, wages and hours, personal injury tort law, and disability law. The last member of our panel is Youssef Hammoud. Youssef is the managing partner of Hammoud Law, PC, a law firm primarily focused on representing consumers under the various consumer protection statutes throughout the state of California and around the country. Mr. Hammoud is admitted to numerous federal courts, including district courts in California, Michigan, and Illinois, and has litigated cases in over a dozen states, including handling arbitration matters filed around the country. In addition, Mr. Hammoud is of counsel to Price Law Group APC, which is one of the largest nationwide consumer protection law firms. In his of counsel role, Mr. Hammoud acts as the lead attorney for all consumer protection cases filed throughout the state of California, including all consumer protection cases filed as a result of workers' compensation claims. Mr. Hammoud has litigated countless lawsuits against some of the largest credit reporting agencies, banks, and debt collection entities in the country. He is known as a tenacious litigator willing to take cases the distance to get results for his clients. His extensive track record of experience in this area of practice and a long track record of success have allowed him to obtain quick and large settlements. I want to thank our panelists for joining us today, and I hope you enjoy this webinar. Thank you. And with that, I'm going to go ahead and let you guys share your screen and get right into it. Thanks.
Okay, so I'm going to start by sharing my screen, and let's see. So let me know when that is good. Do you see that?
Yes. Yep.
Okay, great. So let's see. How do I advance the slide? Okay. I'll be presenting today. So, okay, like I said, the first thing that you will encounter in your practice is a client who will tell you various things during intake. Your potential workers' compensation client, your injured worker, will tell you, they told me to go see my own doctor. With the doctor, pay the copay. I've gotten bills for the ambulance ride, the hospital, the anesthesiologist, the surgeon, the medication. And now I'm getting letters and calls about a debt. I don't know what to do. And like I said, the first thing that I would do is I'd send a letter citing Labor Code Section 3751B, which deals with the cost of compensation, the fact that employees should not be contributing to their own workers' compensation insurance, what happens when there's a violation of this provision, and deals with also the whether employees are to be paying medical providers while claims are pending. So keyword there is pending. The full text of Labor Code 3751 is, if an employee has filed a claim form pursuant to Section 5401, a provider of medical services shall not, with actual knowledge that a claim is pending, collect money directly from the employee for services to cure or relieve the effects of the injury for which the claim form was filed, unless the medical provider has received written notice that liability for the injury has been rejected by the employer, and the medical provider has provided a copy of this notice to the employee. Any medical provider who violates this subdivision shall be liable for 3 times the amount unlawfully collected, plus reasonable attorney's fees and costs. So you can tell this labor code section does have some teeth, but realistically, how often will your injured worker go to a medical provider with their claim form in hand? Most of the time, your client's going to the medical provider and telling them that there's a problem, and the medical provider is going to treat them, especially if it's emergency care. But anyhow, going back to 3751 liability, what triggers liability? It's filing of the claim form pursuant to section 5401. At that point, a medical service provider shall not, with actual knowledge that the claim is pending, maybe they can see the claim form, but if they collect money directly from the employee, there's liability. Unless they have received written notice, let's say a denial letter, that liability has been rejected by the employer, and after they receive that notice, that written notice, they have to then provide that notice back to the employee.
I have a quick question for you.
Sure.
When your injured worker says, you know, I just got a bill for my MRI, should I pay it? What do you tell them?
Okay, so one of my clients received a bill for an MRI. The question is, how did they get to the MRI, the radiology facility? Was the service authorized? Did they get to the facility based on a referral from a primary treating physician within the workers' compensation claim, or did they go on their own? Did they go through their primary care physician to an MRI facility? Those diagnostics are also done through what are called medical legal evaluations, and sometimes the diagnostics are reasonable as part of that evaluation, or they're unreasonable. I'm going to talk a little bit more at the end about some defenses to those types of bills, but I would want to see, more information. How did they get to the MRI facility? What was the reason they had the MRI, and obviously how much are they being billed, because the billing has to be reasonable as well. Anytime I get a bill, I can tell you that anytime I get a bill, if I do receive a bill, I'm forwarding a copy of that bill to the insurance carrier and asking them to pay. So that's generally my practice. So I will tell my client, let's go ahead and take a copy of that. We'll put it on our letterhead and ask for reimbursement or for them to pay.
Good deal. Thanks. Sorry.
So, so let's say that your client goes to get an MRI, and the MRI facility says, well, we want you to sign this lien letter, or this medical treatment authorization letter that says if we only get paid $250 for the MRI, you're going to pay us whatever is unpaid. Is that allowed? Well, the answer is no. There's a case out there from 1976. It's Bell versus Samaritan Medical Clinic, which essentially stands for the proposition that physicians or facilities rendering medical services to industrial injured employees can't condition rendition of treatment on an employee's agreement to pay the difference between the amount of the physician's charges and the amount paid by the workers' compensation insurance carrier. They can't even bill employees for the difference. They can't even attempt to collect the difference from injured employees. In this particular case, Bell was the administrative director, and he was seeking an injunction against Samaritan Medical Clinic. Within that claim, there was another holding, essentially, that treatment providers can't contract out of workers' compensation appeals board exclusive jurisdiction over these medical treatment issues. So the Workers' Compensation Appeals Board in California does have exclusive jurisdiction to decide controversies arising out of medical treatment rendered to injured employees. Whenever a physician undertakes to treat an industrially injured patient and the employer has accepted liability, that's also a key. So we're talking about referrals being generated to a medical clinic, whether directly from the employer through a medical provider network or authorized treatment on accepted liability claims. We're going to talk a little bit more about what happens in a denied liability claim situation, but generally the Workers' Compensation Appeals Board has exclusive jurisdiction over accepted liability claims. Another case that underscores that same issue is the 1996 case, Thompson versus Workers' Compensation Appeals Board, which again references 3751B penalties. They're not applicable against lien claimants who collect from employees after the claim is resolved, or I guess that would be if there's no claim pending. So the facts in this case, CNR 47,600. Within the CNR, the applicant's attorney agreed to a provision for an additional $5,000 for the applicant to be responsible for self-procured medicals that may have accumulated. So there was a radiology group. Maybe they did MRIs based on the amount that was being claimed. So they were seeking to recover $4,764.21. That could be some very expensive X-rays or probably MRIs, but they sued in municipal court. And within that municipal court claim, there was a payment plan agreed to of $150, then $50 a month to reach the amount of the bill. The applicant paid $150 and then filed a DOR for treble damages. So 150 plus 450, which is the 150 times 3. They also sought attorney fees and costs. So the municipal court action was dismissed, and the WCJ in that case issued a findings and award holding the lien was disallowed against the employer due to the $5,000 agreement. So the employer was no longer on the hook because they weren't necessarily a party to the claim at that point. The lien was disallowed against the employee due to laches, so the employee was off the hook. The judge also disallowed treble damages. There was a petition for recon, which was denied. The petition for writ of review is denied. But in the holding, the WCJ did note that 3751 was applicable only to matters in which money was collected from an applicant with actual knowledge that a claim was pending. And so, again, the case was settled. Essentially, there was an F&A. The claim was no longer pending. I'm sorry, the case was not settled insofar as the liens went until the judge dismissed this lien. So, okay, so let's say you're settling a case. You have a CNR, and most of the time what we see in our CNRs is an agreement that the defendant will pay, adjust, or litigate liens of record. But if the applicant's attorney does wish to take additional money to deal with self-procured medical treatment, and one of the potential lien claimants does file a lien or a civil claim for reimbursement of lien, we have some options. Could the applicant's attorney file a DOR? Could they fight the lien? Or in our case, call an unfair debt collection attorney or credit rights attorney. So that's really where Youssef would get involved.
Okay. Joseph, do you want to let me share my screen. Do you want to end your screen share and then I can take over?
Sure.
Let's see. Can everybody see?
So yeah, just
Put it on present. There you go.
yeah. So I just got out of a trial this morning. So we're back in court. Had an in-person trial today in Anaheim. It was nice to get back into the building.
Okay.
And luckily we ended right before the webinar.
Perfect
Yeah,
timing.
good timing.
So as attorneys, as business owners, we all have many goals. Two of our main goals is to help our clients and to make money. My job here today is to give you the tools and the resources necessary to accomplish both of those goals. So I'm going to discuss the consumer protection statutes that we mentioned at the outset of the webinar. These consumer protection statutes deal with two major things: debt and credit, and hopefully we're going to be able to cover them both. The first main debt collection statute is known as the Fair Debt Collection Practices Act. This is a federal statute that applies to third-party debt collectors, and it does not apply to original creditors. What do I mean by that? You have a client who goes and receives medical treatment. They receive a bill from the hospital for the emergency room visit. The emergency room or the hospital would be considered the original creditor, so this specific federal statute would not apply to them. But if that emergency room or the hospital were to send this bill out to a third party to collect their debt, that third party would be considered the third party debt collector, and the statute would be applicable to them. Luckily, we live in the great state of California, where this is probably the best place in the entire country for a consumer, because California has adopted their own version of its federal counterpart. The main difference is that the California statute, the Rosenthal Fair Debt Collection Practices Act, or the RFDCPA, it applies to original creditors. So conduct that an original creditor could do and get away with under its federal counterpart, they would be liable under this specific statute. Now, both statutes have similar goals and purposes, which is to prevent abusive, deceptive, and unfair debt collection practices. They provide broad protections to consumers against debt collectors, and California's RFDCPA to original creditors who engage in unlawful collection practices. So how does the FDCPA and RFDCPA, how does it apply to the workers' compensation world? How does it apply to these injured employees who are coming into your law firms? Well, an injured employee is not responsible for payment of the medical services they receive when the employer has admitted liability. So all medical services rendered to this employee for the injuries they sustained and are as part of their workers' compensation claim, they're not responsible for them. Further, even if liability has not been admitted, but it is still pending and has yet to be rejected, the first $10,000 of medical service provided is also not the responsibility of the injured employee. So if a medical provider or a third-party debt collector attempt to collect these medical bills rendered to the injured employee as related to their injury at work and to the workers' compensation claim, these debt collection laws, the FDCPA and the RFDCPA, they apply. And when they apply, they are separate from the labor code. They work in a separate jurisdiction. They don't implicate the workers' compensation jurisdiction. So medical providers and third-party debt collectors, how do they collect, right? They'll send, the medical providers will send monthly medical statements. They'll even place collection calls. And the other way they collect is they'll send it out to a third-party debt collector who will start to pester your client. Third-party debt collectors, they also collect in similar ways. They'll send you collection letters, they'll place phone calls, and they'll even begin to report these medical debts on your credit reports. Now, with respect to the collection letters sent by third-party debt collectors, these collection letters are required to contain certain disclosures. They can't misrepresent certain things. They can't threaten the injured employee in certain ways. If they set deadlines for amounts to be paid, those deadlines have to comply with the law. So even the letters alone could be grounds for several violations of these debt collection laws. With respect to the collection calls, the laws apply similarly, right? If they're calling your injured employees to collect, there's certain ways that these debt collectors, these medical providers, they have to conduct themselves. What are they saying? What are they representing to the injured employees? All of these things are taken into consideration to determine if there are potential violations of these debt collection laws. With respect to an injured employee's credit report, regardless of the amount of the debt, right? It doesn't need to be a significant amount of debt for the third-party debt collector to begin to report. I've seen them report medical debt allegedly owed as low as $30, right? And even $30 being reported as a collection account on your credit report could significantly impact your credit score, your credit worthiness. It could be grounds for credit denials, mortgage denials, automobile denials, all sorts of things. And we'll touch a little bit later on in the presentation about these credit reporting laws. So again, how does the FDCPA, how does the RFDCPA apply to workers' compensation? As we discussed, if an injured employee is receiving services, the claim has been admitted, they're not legally responsible. So when collection attempts are being conducted by the medical provider, by the third-party debt collector, they are in turn violating these debt collection statutes. They have long list of provisions within these statutes, but some of the main ones are 15 USC 1692A subsection 2, which basically prohibits a debt collector from falsely representing the character, amount, or legal status of the debt. So when they say you owe it, but in reality you don't, it's a potential violation. Under 1692 F1, debt collectors cannot collect any money that is not permitted by law. Again, if liability has been admitted or it's pending and there hasn't been $10,000 worth of medical services provided, the injured employee is not legally responsible to pay those bills. And in turn, if they're attempting to collect, medical providers and third-party debt collectors, they could be in potential violation. Now, I know I cited the federal statute, but California's law, as I stated earlier, it mirrors the federal statute, and a majority of the provisions are incorporated into the state law statute. So attempting to collect a debt not owed by the injured employee would be a violation of both of these laws. On the federal side, it would apply to the third-party debt collectors. On the state law side, it would apply to both the third-party debt collectors and the original creditors. And this would apply again when liability has been admitted, or even when it's pending, but there's been less than $10,000 in medical services. These debt collection laws are strict liability laws. So notice is not required before we can bring a claim. As Joseph discussed earlier, workers' compensation attorneys, their initial reaction in handling this type of situation is to send these bug off letters or other types of letters, which state, this is my client, they have a claim pending, liability has been admitted, they're not responsible, go and file, these medical bills, as a lien.
Youssef, real quick, let me jump in. So so there is, for those of the listeners who are applicants' attorneys and they do want to see an example of that letter, the CEB actually publishes workers' compensation set, and within that set, there is a sample letter to a potential lien claimant or to a medical treatment provider, and it does, I believe, cite 3751, but it also includes information for the medical treatment provider on how to file a lien, and obviously these lien claimants can file a lien. There's nothing illegal about filing a lien at the Workers' Compensation Appeals Board. That's what they're supposed to do. So it's not necessarily a bad idea to check out the CEB in a sample letter. It's not necessarily a bad idea to send that letter, but it's not the only option. Sorry, Youssef, go ahead.
Oh, okay, thank you.
It doesn't actually say bug off, right?
No, maybe it does. Maybe it's just a letter that says, hey, law offices of Joseph Richards, bug off my client.
There you go.
But under these debt collection laws, because there's strict liability, notice is not required. So as we discussed earlier, Joseph discussed 3751. In order for you to bring a claim under the labor code against these medical providers, they have to have actual knowledge and they have to have collected money from your clients. Now, a lot of times what I've seen in my experience is these injured employees, they're not paying any money, right? So with respect to the debt collection laws, it doesn't matter. They don't have to collect, they don't have to pay any money to them. And these bug off letters don't need to be sent. Most of the time, I'm sorry, Joseph, most of the time, what I've seen is the injured employees who are receiving these medical services, they're already informing the medical providers that the injury they suffered is work-related, and that there's either a claim pending or that they filed a workers' compensation claim. And that's enough to assert claims under these debt collection laws.
So is it wise to have a an injured worker consult with the debt collection attorney before deciding whether even to pay even a little bit, even part of that medical bill that they get? Because what if they affirm that debt by paying even a little bit?
So I'm going to get into that in the following slides. But I would always advise that these injured employees, before they make any contact with medical providers about bills, before they talk to any of the third-party debt collectors, to always have a consultation with a debt collection attorney. So with respect to workers' compensation and credit reporting, California has their own credit reporting law that provides protections to consumers. It's known as the California Consumer Credit Reporting Agencies Act. It's a mouthful, CCRAA, and it basically says that a person, like a third-party debt collector, shall not furnish information to the credit reporting agencies about another person that they know or should know to be inaccurate. Now, most of this statute, this California statute, is preempted by its federal counterpart, but this specific provision is exempted. So again, many times the third-party debt collector who receives accounts assigned to them by the medical providers, one of the methods that they use to coerce these injured employees into making a payment is to report something on their credit report. And when they do that, it could potentially lead to additional violations, because if an employee is not responsible for these medical bills, reporting on their credit report that they owe a medical bill is inaccurate, regardless of the amount of money that's owed. Like I said, even if it's $30, it could have a tremendous negative impact on injured employees' credit. And I've seen in my experience, I've noticed that a lot of the injured employees who have workers' compensation claims ongoing, they don't have another source of income. So for the most part, for at least some period of time, they are exclusively relying on their credit and ability to obtain credit to be able to survive. And if a third-party debt collector comes on over and begins to report negative information, inaccurate information onto their credit report, it could significantly impact these injured employees from being able to use their credit and otherwise obtain credit to live. So with respect to the federal counterpart, it's known as the FCRA, or the Fair Credit Reporting Act. In order to have a claim against the furnisher here, or even the credit reporting agencies, there's a series of steps that have to be done before a lawsuit can even be filed, or before a claim has matured. Under the FCRA, the consumer would be required to send a dispute letter to the credit reporting agencies, giving them an opportunity to conduct a reinvestigation of the disputed information. So for example, injured employee, third-party debt collectors reporting a debt on their credit report that they're not legally responsible for. If this injured employee wants to bring a claim against the credit bureaus, or even this third-party debt collector under this federal credit reporting, this FCRA, they would have to send a letter out to the credit reporting agencies. Upon receipt of the dispute letters, the credit reporting agencies are obligated to conduct a reasonable reinvestigation of the dispute. They also have to forward the dispute over to the entity that's giving them that information. So they would send it to this third-party debt collector. And then that third-party debt collector is obligated under the law to conduct their own investigation of the dispute. They have 30 days to do this under the law, and then the dispute results are sent back to the consumer or the injured employee. If the information is not corrected, at that point, there would be a claim under the Fair Credit Reporting Act, this federal credit reporting law that I'm talking about. This is a screenshot. This is a previous client of mine. This is his Experian credit report on his collections. Under the collection section, third-party debt collector by the name of California Business Bureau. Some of you may be familiar with them. You've probably seen some debt collection letters sent to your clients from them. They're one of the larger third-party medical debt collectors in the state of California. Another large one is CMRE, you've probably heard of them. But this is what it looks like on the credit report. So this, California Business Bureau is reporting this account as a collection account. They're saying that the original creditor was UC Irvine, and they're reporting that there's a balance owed of $62. So really small balance, $62, but this was the only negative account reporting on my client's credit report, and it totally tanked his credit score, his credit worthiness, his credit standing. Even if you're in the high 700s, 800s, I've seen something like this affected by over 100 credit score points. So what should the injured employee do, right? And I think this goes to your question earlier, Joseph. So during intake, when these injured employees are coming through your doors and you're having a conversation with them, they should be informed that because your workers' compensation claim is admitted or pending, you are not legally responsible for these medical bills that are coming for treatment received related to your injury. And that any collection attempts by either the medical provider or the debt collector, those collection attempts could be potential violations of debt collection laws. And if they're receiving any statements, any bills, any collection letters, any phone calls, that at that point in time, they would be referred to a debt collection attorney who can help discuss and explain everything to them. They should be told that the debt collection attorney would review these medical statements, that review these collection letters to determine if any laws have been violated. As I discussed, the collection letters themselves from third-party debt collectors can contain significant violations within them. That there is no charge for speaking to the debt collection law firm. I'll explain why most debt collection attorneys don't charge later on, but there is no charge for speaking to the debt collection attorney. That all medical statements, bills, collection letters, collection calls they receive, they should keep a record of all of it. They shouldn't throw anything away. They shouldn't, they should keep a record of everything. And they should be provided the intake form that John had talked about at the outset, that's going to be shared with everybody. So there's two forms that are going to be shared. One of them is for your respective law firms, where if you have a client and they're having this type of issue, it's a form where you could put in their information, fill it all out, and then you could refer it out to a debt collection attorney for their review. And the other form is for your clients themselves. So, upon intake, it would be a good idea to give them these forms along with, these instructions. And these forms are tables that ask them questions and help them keep track of all medical statements, collection letters, collection calls, notes of any conversations they'd had with them. Just a good way to keep record of everything. So if
Youssef, sorry to cut you off, but we're, as applicants attorneys on intake, we should already be doing this. We should be making a list of every medical provider that our client has seen, because at some point we may need to request those records. We may need them to support our claim, to forward them to a qualified medical evaluator. So what I'm probably going to end up doing is on my intake sheets is just add a couple columns for, have you been, now that we've listed out all of the different medical providers, have there been attempts to contact you by the medical providers? Have there been, collections attempts, phone calls, letters? And it's just one way to update your intake form for everybody else listening.
And the form that John's going to be circulating, they have that. So they'll say who is attempting to collect, you write their name, or have they been sending you medical statements or collection letters, yes or no, right? And just a way to keep track of everything. So the other instructions that need to be told to these injured employees is, if you are contacted by a medical provider or a debt collector, right, because they're placing collection calls to them, that they should not speak with them without first speaking with a debt collection attorney. And the reason why I say that is because the initial communication from a third-party debt collector or medical provider is very important, right? When I have clients come to my office who are injured employees, right? If Joseph is sending somebody over, we do a good job of talking to this injured employee of everything that's going on in their life. aside from, the workers' compensation claim, or it could be as a result of, their injury at work, whether they're not working, they don't have a source of income, they've already, they've been sick, they care for their elderly parents, they have a sick spouse, a sick partner, they got a whole bunch of kids at home, they can't afford to put food on the table. During the day, they're at work during specific hours and they can't have calls during specific hours. All this information is important because we use it to advise these injured employees how to handle these initial calls when they come in. And after we instruct them how to handle these calls, if the calls continue, it could be grounds for violations of these debt collection laws. The other thing that should be emphasized is, again, injured employees should not throw away any medical statements or collection letters. I've seen sometimes when injured employees, they come through the doors over here, sometimes they weren't advised or instructed properly at the outset. They don't keep track of these medical statements or collection letters. And those are just claims we're flushing down the toilet, right? Potential claims, we flush them down the toilet because they say, oh, I remember, it was this hospital, this medical provider who sent me a bill. Okay, we could go off of that, but later on we find out that there was another individual who was attempting to collect, but maybe it's past the statute of limitations at this point. We can no longer bring the claim, and the injured employee loses out on one, making money themselves, and two, potentially getting these medical providers or third-party debt collectors to leave them alone. And then three, the injured employee should be informed not to block any numbers that are calling to collect. I've seen in a lot of cases, again, when these injured employees, they don't know how to handle these calls, they don't know what they should be doing. They'll be receiving collection calls, and these collection calls, these third-party debt collectors, they can really bombard you. It's an assault on your cellular phone, maybe your home phone. And what they want to do to make the call stop is they just block it. But when you block it, again, we're missing out on potential claims, potential money for the injured employees, making them go away for good. And just ignoring it doesn't work because it could make the problem worse, right? We're ignoring it. We don't know that this third-party debt collector is trying to contact you. Later down the line, you end up getting sued by somebody for this debt that could have otherwise been taken care of, that you could have potentially made money on. And so it's very important to let them know, don't block any numbers, don't throw away any of the letters that you're getting. We'll keep a record of everything. So how to find an attorney if money is an issue for the injured employee. A lot of times these injured employees, their source of income is gone, right? They're not doing well, they don't have any money. And when you tell them, oh, we're gonna refer you to a debt collection attorney, the first thing that comes to their mind is, well, I don't have any money to pay another attorney, right? I don't have money to talk to an attorney. But thankfully that Congress, when passing these debt collection laws, these credit reporting laws, they understood that the individuals who are being harassed by debt collectors, the individuals who have problems with their credit report, are usually people who don't have a lot of money, right? And so within the statutes themselves, the federal statutes and the state statutes, there is a fee shifting provision built within those statutes that says if the consumer prevails on their claim, one of the things that they are entitled to is their attorney's fees and costs. So for example, my firm, even at Price Law Group, we don't charge any clients that come through the door. It doesn't cost them any money to talk to us. We help build their case for them. They never pay us any money at all. And when we bring their claims and when we prevail, then the attorney's fees and costs get paid. The client gets paid, right? They're entitled to certain statutory damages. And so the client will never pay. Even if we are unsuccessful on a claim, which is rare, but it happens, right? The client will never pay. So it's $0 coming in, it's $0 going out. And most of the time, 99% of the time, my clients, when we're done with their claims, they have money in their pocket. The debt that's being collected has gone away and they pay us nothing out of their pocket. If there's credit issues, we correct their credit issues as well. And we cover it all. Again, this is irrespective of the workers' compensation claims. Even in the settlement agreements, I tend to make it a habit to ensure that there's no 1099-C being sent to my client, right? Because I tell these medical providers, when we're settling these claims, you're not going to collect anymore because my client doesn't owe it, and you're not sending a 1099-C because we dispute they even owe this money. So you do what you have to do to file a lien, but this is the way that we're settling these claims. And then the injured employee should also be informed that when they speak with a debt collection attorney, all this information, all the instructions on what to do, how to handle the calls, the letters, what they should be doing, will be provided to them by the attorney. So most of the time, it's good habit that if you have a client who comes in and says that they're being contacted by medical providers or debt collectors, they're receiving statements, at that point in time, they should be referred out. And these debt collection firms, these attorneys, they can handle the claims from there, right? So instead of bombarding your office with keeping track of all the medical statements, everything that's going on and the claims and following up, the moment that the injured employee tells you that this is going on and now this is potential claims, you can refer it out. The collection attorneys, at least our firm, will handle everything from there. We'll take care of the intake process. We'll let them know to send all statements to us. We'll stay in touch with them. We'll instruct them about everything. So that way the workers' compensation firm that's referring them, their staff is free to focus on, those other claims. And for the most part, at least our firm for these types of claims, right? There's a referral fee to the workers' compensation firms that are sending these clients over. Youssef could, he's here, he's a witness to some of these referral fees, and it's just another source of revenue for your respective law firm. So helping you get more money as one of the goals, and then two, providing additional help to your clients, right? Most of the clients, they're happy. They're not paying any additional money. There's more money going in their pocket, and they're not being pestered by, debt collectors or medical providers because they have an attorney who's representing them and otherwise taking care of it for them. Okay, Joseph, I think this is.
Yeah, Youssef, thank you. I'm going to share my screen now. We have I just want to take 5 minutes and talk about what happens, if all else fails and you're stuck in a situation like the Thompson case where you actually have to fight the lien. So remember, I was a defense attorney for a minute, and I learned a few tricks. So I'm going to just share some tips. Are there any? How much time do we have? I'm going to just take 5 minutes.
We're at about 10 minutes, and we have just a couple of questions here.
Okay, great.
So go ahead and take 5 minutes, and then we'll get into questions.
Okay. So how to fight lien conference to trial. So we present to a lien conference, and you have to sort of flip your thinking a little bit. You spend most of your time as an applicant's attorney arguing that the treatment your client got was reasonable and necessary. And then if you get into a situation where you now have to fight a lien, you have to flip the script a little bit. You have to come up with creative ways to fight that lien. So number one, lien claimants have to file a notice of representation, and it has to comply with CCR 10774.5 et sec. If they don't comply exactly, then the notice of representation is defective. And what does that mean? That means the lien claimant has not appeared. That's a failure to appear. If there's a failure to appear, the court can issue a notice of intent to dismiss the lien. So next question is, does the amount of the medical bill exceed the official medical fee schedule? So while OMFS is not applicable to denied or contested cases, it is an argument that can be made at the time of a lien trial that the bill is excessive. How about, what if the doctor was negligent and actually aggravated the injury? How could their treatment be worth anything? It's an argument. How about the carrier or the TPA authorize the services? How about, and again, it comes back to, if all else fails, Youssef hasn't been successful, God forbid. I don't know if that would ever be the case, but let's say you can then tell your client, just pay part of it. And the lien claimant fails to timely object. And in thinking about this last night, I was thinking, does the UCC, Uniform Commercial Code, apply to durable medical equipment? If you write full and final satisfaction of any and all debt in the form of a smaller check to the provider of DME and they cash it, does that mean that the debt goes away? I don't know. So you can argue reasonableness and necessity, frequency and duration. If the services were arguably med legal and the diagnostics were done like these MRIs that we were talking about earlier, there's an argument that the diagnostics weren't reasonable because maybe there were diagnostics done recently and they were duplicative. How about the treatment provider wasn't even licensed? They had no education or professional license. We see this all the time, issues arise with who the injured worker is actually seeing when they go to a medical facility. Is there even a doctor in the house? I think these are reasonable arguments to make. How about failure to support the billing by establishing a market rate, providing information on the physician's or provider's usual fee? How about just a blanket argument that there's no explanation for why these services were provided? The services were unusual, and there's no explanation of the extraordinary circumstances related to the unusual nature of the services. How about the provider was a prohibited referral? The physician or the immediate family had a financial interest with the person or the entity that received the referral. There's a potential fraud issue there. How about statute of limitations? There are some statute of limitations listed in 4903.5 as well. Laches, waiver and estoppel. These are basically arguments that the lien was filed untimely. So what happens if there's a failure to appear, a failure to offer any evidence or proof? Can sanctions be sought? Yes. How about a failure to object to the court's notice of intent to dismiss? Remember, you're going to flip the script on a lien claimant. Let's say they exceeded the 24 visit cap on chiropractic, PT, or acupuncture. So you're basically stepping into the shoes of a bill reviewer or an insurance adjuster in that case. How about the person who provided the treatment was using a fictitious business name that wasn't permitted? They didn't have a license in the locality where they were trying to do business. This is a common issue. How about they try to assign that debt to someone else to collect? There are rules regarding assignment. There are a lot of rules, and I don't have time to get into them right now, but let's say that assignment itself was invalid. The person who performed the services is not the one collecting the debt. It's been assigned somewhere else. We have issues with compounding pharmacies, repackaging drugs, taking ibuprofen, mixing it with something else, charging $1,000 instead of $10. These are common issues. At the lien conference, discovery is closed. You have to make sure that your lien claimants filed their filing fee contemporaneously to the time of filing the DOR and the lien. How about your lien claimant failed to properly serve medical supports in support of their building? How about the reporting fails to conform to Title 8 CCR 10682 and 10615? Failure to properly document the lien via itemized billing, required reports, and written authorization. So you have a lot of evidence you can use to your client's advantage. If you ever have to fight a lien, there are AME, QME reports, the MSC pretrial conference statement of the case in chief, the compromise and release, the stipulations with request for reward, the FNA, the summary of evidence, UR determination, bill reviews, EOBs, objection letters, benefits printout, deposition transcripts, the liability letters, any comparables on DME, durable medical equipment, and any other notices you feel are important. Witnesses, you can list the adjuster. Why not? You can list the claims examiner, bill review experts. When a lien is filed, there's a declarant that has to be listed as well. So the lien claimant's declarant under 4903.8 has to be listed. You can list that person as a witness as well. Any employer witnesses or lien claimant representatives or the injured worker as you see fit. That's the end.
So thank you. As a good presentation, we have a number of questions that have come in from the audience. So I'm going to go ahead and start with those instead of the other questions that I had here. So let me start with one that came in from Benjamin Helfman. It says, does the WCAB have jurisdiction to award the treble damages per the LC statute prohibiting this collection?
Yes.
I like that answer. Nice, short and sweet. David, you want to grab the next one?
Yeah, it says this is most often a problem for clients with denied claims. How do we leverage these laws to help them?
That's a very good question. I know we talked a lot about admitted claims, pending claims, and we never really touched base on the denied claims. However, as discussed in the presentation, the collection letters themselves that are coming in, right? These could be potential grounds for violation, even if the claim is ultimately denied. So if a third-party debt collector is making threats in a letter, if they're not including the required disclosures as required by the federal and state law, these could be potential violations. If they're placing telephone calls to you and the injured employee is answering the phone and they just explain their situation. Look, I was injured, I'm out of work, I don't have any money, I get debt, over my head, I'm drowning, I got 4 kids, I'm trying to put food on the table. I can't make a payment to you right now. When I get some money, I'll call you to make a payment. Most of the time, they're gonna keep calling your client. And when they do, regardless of the status of this workers' compensation claim, these are grounds for violations of the debt collection laws themselves.
The third one is kind of on that same idea. The discussion has been limited to pending and accepted claims. I'm in the process of settling a denied claim via CNR. Defense insists on a Thomas finding. Claim was denied because applicant was likely not an employee, but an independent contractor at time of injury. Would a Thomas finding vacate these debt collection protections discussed here today?
So Youssef, the Thomas finding is basically, it requires the judge to thoroughly review the record, determine whether a serious and good faith issue exists to justify. It's a release that basically says a good faith dispute exists as to compensability, and if evidence were presented, then it would completely bar the recovery of benefits. So the judge has to make an express finding of that and explain the reasons for finding it. But that is a basically as general of a release as you're going to see in a typical workers' compensation CNR.
Okay. So my answer to the previous question would apply here, that irrespective of the ultimate status of the claim, whether it's admitted, whether it's rejected, these debt collection laws will apply, right? The debt collection laws, they're separate and distinct from the workers' compensation jurisdiction, so they don't require them being admitted or them being rejected for there to be potential claims. The potential claims can be produced outside of any result in the workers' compensation world. With respect to the Thomas finding, thanks, Joseph, that was going to be my initial question. What is a Thomas finding? If ultimately it's ruled that these medical bills, the claim is denied and the injured employee is responsible for them, then that would just tell us as the debt collection attorneys, okay, we need a new way to attach liability to these medical providers and third-party debt collectors than alleging that they're collecting on money that's not legally owed. And we could do that through the numerous ways we've discussed. What are they being told in the collection letters? What are they reporting? And what are they telling them when they're calling them? And how often are they calling them?
And obviously, if the claim is CNR, like in the Thompson case, I think it was the Thompson case, then the claim is no longer pending unless you write it. You maybe consider whether to write into a CNR, defendant to pay, just litigate any and all liens or potential liens and holding applicant harmless. In addition, workers' compensation appeals board jurisdiction is reserved. And obviously the other parties, like the debt collection people, they're not a party to the CNR either. So I don't see what would prevent Youssef from addressing those issues even after a CNR.
All right. We have one more question, and I'm going to go ahead and let David.
Yeah, we have a great question. Thank you, John. We have a great question came in from Charles Chan, and it's been a question that I've been waiting to ask as well. He asks, do these debt collection laws apply to PI cases? And we've also had some personal injury attorneys on this webinar as well. So how does that, how does what we're talking about tie into or impact their business?
So does it apply, do the debt collection laws apply to PI cases? The short answer is yes. Again, irrespective of what's going on in those specific worlds, the PI world or the workers' comp world, these debt collection laws, they stand on their own, right? So we get a lot of referrals from PI law firms. They have a client injured in a car accident, they're not working, and as a result, they don't have a source of income. Maybe these injured clients are planning on missing their next credit card payment. Maybe they have people who are calling them already. But again, that would be the time that they should get referred out. So if they intend on missing their next payment, what happens after missing a payment? They start receiving collection calls, starting with the original creditor, whether it's Chase, Citibank, Bank of America, whoever it may be, before it gets passed on to a third-party debt collector. And that initial call that they have when the collection calls are coming in is very important. What they say on that call and what they tell these creditors and third-party debt collectors is very important, because if the calls continue after that, it can be grounds for bringing these debt collection claims. And as I said earlier, in almost all the cases that we bring on behalf of our clients, I mean, I've seen some, they have, debt, $2,000, $3,000, $4,000, $10,000, $15,000 worth of debt. As part of these claims, when we bring them, we make this debt go away. That's one of the goals that we have in bringing these claims. So when it's all said and done, they don't owe nobody any money. We try and put as much money as we can into their pockets. And obviously, right, they don't pay any money for attorney's fees or costs.
Great. Well, thank you very much. We're right at time of an hour. So I know we do have one more question, which is what is Youssef's contact info? Like I said in the beginning, I am going to send out some follow-up materials, including the intake things to add to your intake form and a few others, along with both of the attorneys, the panelists here, contact information. So with that, I'm going to thank the panel for joining us. Thank you, David, my co-host, for joining us as well. I hope you all got something that you can use in your practice right away to help both your clients and also for your practice to make some more money. And I look forward to seeing you on the next webinar. So thank you very much, everybody.
Thank you, John. Thank you, Dave. Thank you, Youssef. And thank you, Gemini, for hosting this webinar.
Great. Thank you.